Go ahead. Hello. No. Not that I know. Was it an email or? I thought it was mandatory to go. What time today? Well, I know we got. Okay. I was gonna say because we got 1 o'clock, and I can do it at 11. That's what I'm scheduled for. Not here. Because Ontario, he's on vacation. Yeah.
All right, welcome everyone. This is the detention docket for the 323rd District Court on Monday, December 28th. Advice of the Texas Supreme Court Emergency Order number 30. We are not conducting in-person proceedings.
Yeah.
However, we are using a reasonable alternative, which is Zoom. To comply with the Texas Constitution Open Courts Act, we are broadcasting these proceedings on YouTube so the public may observe the proceedings that are happening inside a public courtroom. No portion of this detention hearing may be copied, recorded, or broadcast. Violation is punishable by contempt of court of up to 6 months in the Tarrant County Jail and a $500 fine. The court does expect everyone to understand this is still a court proceeding, so we expect everyone to behave appropriately for court. So that means please do not be laying down or in bed or in the lavatory. Please refrain from having domesticated animals walking across the screen. We also ask that you don't have any moving objects or bright lights in the background or be in a moving vehicle, as this is distracting for everyone participating. We also do ask, if you are not an officer of the court, that you have your cameras on and you remain still and not walking around. So I'm going to ask Ms. Holland and who else? Amanda Holland, Joseph Williams. Your cameras do need to be on for these proceedings. All right, so we'll start with Jeriel Harris, who I believe is in the Tarrant County Jail. Mr. Harris, good morning. I'm Judge Kim.
Morning.
Morning. All right, so we're at a 10-day detention hearing. So you've been here for 10 days. I'm reviewing your case. You're almost 18 years old, and you had a warrant issued for you for a, the purpose of the hearing is to decide whether to keep you here or to release you. If I keep you here, you have to see a judge every 10 days. You do have a right to remain silent. You have a right to an attorney. Ms. Lothorpe is your attorney. So you had a probation violation set to expire on your 18th birthday in January. However, there was a violation, and so we issued a warrant and brought you in. You also have new offenses as an adult for unlawfully carrying a weapon, assault, bodily injury, and theft of a firearm. And we issued a warrant because you are not reporting. Since you didn't report while you're on probation, I'm afraid that I don't think you will appear for court, so I'm going to go ahead and continue to detain you. All right. Thank you, Mr. Harris.
I got a question.
Yes, sir.
You detained me like 4 times. I'm been here going on 3 months. Don't you think I've learned my lesson?
I'm sorry. I heard if you're going to detain me, I've been here for 3 months. I didn't understand the rest of it. What did you say?
I said, you detained me going on 4 times. I've been here going on 3 months. Don't you think I've learned my lesson?
Do I think you've done your what?
Learned my lesson.
Oh, learned your lesson.
Yeah.
Well, I mean, at this point, we still got to deal with your case. You are on the aggravated robbery case, and so we have to figure out what happened with your probation or not, because you could still be committed. And so I'm not sure what's happening, but until your 18th birthday, it looks like who's the probation? So Mr. Houston?
Yes, sir.
All indeterminate?
Indeterminate.
Okay.
Yeah. Okay.
Yeah, so Mr. Harris, the juvenile system's not here to punish kids, like to teach you a lesson. It's for rehabilitation. And so you are scheduled to appear before Judge Porter on January 4th to take care of your case. So if everything wraps up, then everything's wrapped up, right? So, but I want to make sure you understand, I'm not really here to teach anybody a lesson. That's not what the juvenile justice is for. We're here really to help you make better decisions, okay? All right, thank you, sir. All right, we have Cameron Newton. Also believe in the Tarrant County Jail.
Good morning, Your Honor.
Good
morning, Your Honor.
I'll be coming from P.O. Smiley.
All right. I don't think so.
Your Honor,
Yes.
now we have Mendoza here in Green Bay.
Okay, we'll do Mendoza. Is Cameron Newton kind of on deck? Sheriff?
Yes, sir.
Is Cameron Newton on deck?
I don't think we have them. We're at Green Bay, and we only had 2 for you here at Green Bay.
Okay. All right, we'll try and.
They may be downtown.
He is downtown, Your Honor.
All right, thank you, Sheriff. I didn't find out about that one. All right, Mr. Adler, are you here?
Yes, sir.
All right, great. All right, Mr. Mendoza, I'm Judge Kim. This is a detention hearing. I'm deciding whether to keep you or release you. If I keep you, you have to see a judge every 10 days while you're here. You have the right to remain silent. You have the right to attorney. Mr. Adler?
Señor Mendoza, esta audiencia otra vez es la audiencia de 10 días. El juez va a decidir si te vas a quedar ahí o te vas a dejar salir mientras tanto.
Okay. All right, Mr. Mendoza, I'm familiar with the case. You had the previous case, you absconded, and you were caught trying to leave the United States into the Republic of Mexico. So I'm concerned if I was to let you go, that you would not appear for court. So I'm going to go ahead and detain you.
Señor Mendoza, ¿usted entendió lo que dijo el juez o quieres que yo te lo diga otra vez en español?
Mendoza, do you have any questions?
Por favor.
Okay, el juez dice que él conoce a este caso y lo conoce porque ya llevamos mucho tiempo y este es el caso que te ibas a ir a la República de México y por esa razón él tiene preocupaciones y te va a quedar ahí mientras que tenemos la otra audiencia.
Do you have any preguntas, Mr. Adler?
¿Tienes preguntas para el juez, Benito?
No, gracias.
No, thank you.
Okay. All right. Thank you, Mr. Mendoza.
Thank you, Judge.
All right. While we're waiting on the downtown jail, let's go to Bria Lynn Christine Anderson.
Is Mendoza finished?
No. Mendoza is finished. Thank you, Sheriff.
All right, thank you.
Yes, we're waiting on Cameron Newton, but he's in downtown and they're in the process of logging in. Do we have Bria Lynn Anderson?
Right
please?
here, Judge Kim. We're right here.
All right, thank you. All right, Bria Lynn, I'm Judge Kim. This is a detention hearing. When a kid's brought to our facility, you have to see a judge within 2 days, 2 business days. I have to decide whether to keep you or release you. If I keep you here, you have to see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. If you cannot afford one, we'll provide one for you. Ms. Tillman has been appointed as your attorney. Good morning, Ms. Tillman.
Good morning, Your Honor.
All right, so Bria Lynn, let's see. You have been here before in 2018 for assault, bodily injury of a family member, and an assault public servant. The victim for the family violence dropped the case. The assault public servant our probation department decided to give you a supervisory caution, basically said, hey, looks like you learned your lesson. And so please make good decisions and we won't see you again. So now, let's see, you're 16 years old. You were referred on Saturday. Let's see, according to the police, that the police responded to domestic. Dad said that he and you got started arguing and you refused to respond when you knocked on her door. And there's an argument. And then he said he was going to take your phone. Then you got upset, got in his face and pushed him. When he tried to restrain you, you punched him. At some point, punched the flat screen television inside the room. And when the police got there, your hand was bleeding. What did the TV do to you? All right, so MedStark showed up, bandaged your hand. Dad had a scratch on his face. And father refused medical attention, refused to allow police to photograph his face, and refused to complete a family violence report. So you were arrested and brought here for family violence. So since you have a history of assaults, this can be referred to the DA. So we're looking at mediation as possibly this week. All right, do we have a parent here?
Your Honor, I sent the Zoom link to Father about 15-20 minutes ago. I'm looking for him, but I'm not seeing him. It should come as Texas Soldier Man at Yahoo.
Oh, ma'am, I said Anderson.
I'm Anderson. I'm Miss Anderson.
Or Raylan Anderson?
No.
Oh, okay. I'm calling by the telephone.
Okay. All right, thank you, Mr. Lewis. All right, so Whelan, even if your father historically has always asked the police or the DA to drop the case, there's a certain point the DA can pick up the case even if they don't want to go forward. And so this is not a game you can play with the criminal justice system. At this point, since your dad's not here, I'm not willing to release a 16-year-old girl out on the streets on Sylvania or North on 28th Street. So I'm going to go and detain you. Hopefully there's mediation available and we get this all worked out. You better make better decisions while you're here. All right. So at this point, I'm detaining you and hopefully we get mediation, Mr. Lewis.
Yes, sir.
All right. Thank you.
May I ask a question?
Yes.
I will try to get in touch with the father today. If I'm able to get him present, could we reset a detention hearing and try to get my client out before the end of the week?
We can, but because of the county holidays, we are only running detention hearings Monday and Wednesday this week. So it would have to be on Wednesday. If not, it would be next week on Monday.
Okay, I'll make an effort. Thank you.
Thank you, Ms. Tillman. All right, so we have the downtown jail brought in Mr. Newton. Mr. Newton, I'm Judge Kim. This is a 10-day detention hearing. I'm deciding whether to keep you or release you. If I keep you here, the law says you have to see a judge every 10 days. You do have a right to remain silent. You have a right to an attorney. Your attorney, Ms. Keenan, I saw Ms. Keenan, good morning.
Good morning. Sorry.
Okay, oh, that's all right. All right, so Mr. Newton, you were, well, let's go back. This is about the robbery. I believe it's over somebody threw an AR-15 in a trash can after a robbery. And I think the video has you at the location and found a .223 round in your pants pocket. So, and this has all happened while you're on probation for stolen car, unlawfully carrying a weapon. You've been on probation for, well, your previous arrest for aggravated robbery and robbery. Mr. Newton, do we have a parent here for Mr. Newton?
I don't believe so, Your Honor. It would be his grandmother.
Right.
Let me see if I can see.
I don't see either.
I don't see her on here.
Mr. Newton, I'm deeply concerned if I was to let you go that the community would be in danger and you would be in danger because of your history with weapons and with violence. So I'm going to go and detain you. All right. Thank you, Mr. Newton. Joshua Ballard. Sheriff, thank you very much for being this inmate.
Welcome, Judge.
Your Honor, I believe I have an inmate also. Don't know which location, but.
Ms. Lothorpe, that was Mr. Harris. That was the very first one we did from Green Bay, and so we already went forward. He was the first one on the docket for today.
Well, I know I was about 2 minutes late, but my computer was off and I was having technical difficulties opening it, but.
That's right.
So did you waive it or did you put him back at the end? Or what? I just need to know what we're doing.
No, he was detained. Ms. McGonigal was here. She's the attorney of the day to cover when there's an
Thank you
absence.
very much.
Thank you, Ms. Lothorpe. Have a happy new year. Joshua Ballard. have Joshua Ballard?
We're here, Judge.
All right, great. Hello, Mr. Ballard. I'm Judge Kim. This is a 10-day detention hearing. I'm reviewing your case, deciding whether to keep you or release you. If I keep you here, you have to see a judge every 10 days. You have the right to remain silent. You have a right to an attorney. Your attorney is Mr. Pearson, who I think, good morning, Mr. Pearson.
Good morning, Your Honor. Present.
All right, great. And then do we have a parent here for Mr. Ballard?
Your Honor, I do not see the mother on the screen.
Okay, all right. All right, so Mr. Ballard, you're 14 years old. And see, currently, so you're placed on probation back in March for criminal trespass. You got arrested for theft and terroristic threat since you were placed on probation. And then now back in August, Arlington PD brought you in for a shooting. There was a shooting call. The victim shot multiple times, transferred to Arlington Memorial for surgery. And I guess it was a robbery inside of an apartment. When the police got there, bullet holes in the window, shell casings on the ground. Another victim said that they were there at the apartment, 3 black males outside the front porch. Owner told them to leave, but they refused to. There's an argument. All 3 males had handguns. Assaulted one of the people, stole cash. Demanded more cash. They shut the door on the 3 black males, and then there were gunshots into the apartment. So one of the victims said he knew 2 of the males, got the Instagram profile. Came back to Joshua Ballard. So, all right. Well, Mr. Ballard, because of severity of offense, you are level 1 outstanding. I'm glad to see that. Mr. Jennings, how long has he been level 1 outstanding?
Your Honor, he most recently since December 24th.
Oh, why did he drop down? Do we know?
Yes, sir. Give me one moment, please. On the 16th, he was cursing at staff, defiant. He was confined at that time. Got up to level 3 outstanding on the 17th. On the 18th, he had a major infraction for constant disruption, not following instructions ×6.
All right, so Mr. Ballard, I hope you know all this stuff will come back out when it's time to have your trial. So I encourage you to behave your best. I'm glad you made your way back up to level 1 outstanding, but please be careful. But no, I'm seriously concerned about the safety of the community, the safety of you. You understand my policy when it's kids with guns. I take a very hard line on that. All right, so I'm going to go ahead and continue. Thank you, Mr. Ballard. All right, we have Cameron Durham.
He's out of custody, Judge. He's walking in.
Yes, sir. All right, Ms. Holland, I'm going to ask you to turn your camera on. Mr. Williams, I'm going to ask you to keep the bright light from not behind your head. It blocks out. It creates a shadow of your face so we can't see you.
You can hear everything y'all are saying.
All right, so Cameron, I am Judge Kim. This is an out of custody detention hearing. The purpose of this hearing is for me to decide whether to take you into custody or to leave you in the community. If I take you into custody, you need to see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. We have appointed Ms. McGonigal as your attorney for the purpose of this hearing. All right, so let's see, Mr. Durham. So you are currently on DPP for possession of marijuana. So it's a little offense, and we are just trying to make sure you make better decisions in your future. And so we did a substance abuse assessment, and we're waiting for the results. And then we'll refer you for substance abuse treatment for the weed case. Okay, 16 years old. So let's see, Mr. Durham. However, on December 23rd, there was a kid that was in a car pulled over, weed coming from the car, and they searched the vehicle. They found a loaded handgun and marijuana, and the gun was stolen out of Louisiana. And the police also noted that you were a documented member of the Blood Gang, and you were on DPP when you're found in a car with a kid who has a gun and weed with the odor of marijuana coming from the car. So I want to talk to you and see what's going on. So first question is, Ms. Smith, are you here?
Yes.
Okay, did we give him a drug test?
Yes, we did, Your Honor. He was positive for marijuana.
Okay, so we saved the sample. We're gonna send it off to a lab.
Yes, Your Honor.
Have we taken a sample from him before?
Not that I'm aware of, no.
All right, so Mr. Durham, at this point, I'm gonna assume that you're positive for marijuana. Well, Ms. Smith, let me ask you this. When did he get into DPP?
He was signed up on December the 11th.
Okay, so a couple weeks ago. All right, so Mr. Durham, I'm going to give you the benefit of the doubt that you're positive for marijuana is because you had smoked so much marijuana before getting into DPP that you're still testing positive for it because it can last.
Your Honor, he admitted to using marijuana about 5 days ago.
Okay, all right. So, Mr. Durham, I'm going to give you the benefit of the doubt, okay? You just got to DPP. We haven't had the opportunity to get back the assessment, haven't referred you for counseling or treatment. I need you to understand that marijuana is illegal. People can talk about whether there's good benefits to it or not. That is not my point. My point is it is against the law in Texas. If you really want to smoke marijuana that much, you can ask your mom to go ahead and move you to Colorado or California or Alaska or any other state that marijuana is legal. However, it is not legal in the state, and I expect you to follow the law in the state. I'm not worried necessarily about the marijuana itself as much as your desire and your willingness to break the law. That is my concern. Okay. Now that I'm saying that, I also want to have this face-to-face with you so that you understand that if you are in a vehicle or associating with other people that are breaking the law, that you can go down for their breaking the law. I hope you understand that you're in that car with the kid from Louisiana, and if the police decide to, they could have put the marijuana or the gun on you just by being there, right? That's the police officer's decision. And even though there's a saying that we have in the law, a saying, just because you can beat the rap doesn't mean you can beat the ride. Right? They could arrest you and you would have to come to court, have your attorney fight the case just because you were hanging around the wrong kind of people. Mom, do you know the people that he was hanging out with on the 23rd when they got pulled over?
No, he was supposed to be getting a ride home.
All right, so see, this is kind of more of the problem here, Cameron, is that if you're not telling your mom the truth, then you are going down the wrong path, right? At this point, you're only 16 years old. You need to act like you're 16 years old, which means listening to your mom, respecting your mom, following her rules. What I do not want to have to do, have you been inside Kimbo before, Cameron?
Yes, sir.
Okay, so you know about what we call a DNA here, right?
No, I ain't never heard of it.
A DNA means do not associate. So once you're in here, there's behavior levels and you get certain points. You need a level 1.0 for me to let you go. I do not let kids go if they're not a level 1.0. So if you're back here and you're associating or affiliating with people they tell you not to, you lose points so you don't get out until you follow the DNA order. The same thing goes for your home and your mom. If your mom says you are not hanging around those people, you will not hang around those people. You have to follow her rules. And this is why I'm saying this, because you can either follow the rules in your mom's home or you can follow the rules here at Kimbo at my home. Okay? And it's your choice whether you want to be sleeping in your own bed or sleeping in this bed here. You understand what I'm saying?
Yes, sir.
So it's your choice where you're going to spend your nights, where you're going to eat your food, what kind of food you're going to eat. You're deciding this, but your decision has to start with listening to what your mom says and respecting her and following her rules. Your mom will keep you out of Kimbo. Your friends will bring you back here. You understand what I'm saying? So I want to take this chance as a good, call it a teaching moment for you to understand. You cannot hang around people that are breaking the law, not while you're on DPP. After DPP, you can make that choice to say it's worth the risk of going back to Kimbo or to Tarrant County Jail. But while you're doing this, this is not your option. You understand?
Yes, sir.
So we are taking your urine sample. We're going to send it off to the lab, and we're going to get the tetrahydrocannabinol levels. We will know how much marijuana levels you have in your system, your THC levels, and we will monitor that. And as long as your levels are going down, that means you are not using THC, and I'm fine. You and I are good. But if that level ever spikes, you are going to bring your toothbrush, all right? Because you're going to be here at Kimbo for a while. You understand what I'm saying?
Yes, sir.
You'll be rejected out of the DPP program, and then you will have to deal with a formal juvenile case against you. This all starts with your mom. I guarantee you. You listen to your mom, you and I'll be fine. If you're going to do it your way and act like an adult, I'm going to treat you like an adult, okay? So you understand, I'm trying to be fair to you, right? I'm giving you this free pass because we're having this conversation, okay?
Yes, sir.
All right, so should I expect to see you again?
No, sir.
All right, this is too much for you already, right? Mom, are you and I on the same page?
Yes, sir.
All right, and if he's disrespecting you, then you know what? You need to let Ms. Smith know, and we will take care of this. You and I together are here to help Cameron while the short time that we have until he becomes an adult, okay?
All right.
All right, thank you, Mom. Thank you, Cameron.
Thank you, Judge.
Thank you, Ms. McGonigal. We will go to Damian Jackson. All right, so Mr. Jackson, I am Judge Kim. This is a detention hearing. I'm trying to decide whether to keep you in custody or to release you, or keep you in the community. If I take you into custody, that you have the right to see a judge every 10 days while you're here. You do have a right to remain silent. You have a right to an attorney. We have appointed Ms. Craven as your attorney for the purpose of this hearing. All right, Damon, I want to go over this with you. So you're 17 years old, and I'm bringing you in because you are currently on probation. Right? Is Ms. Brown here?
Yes, Your Honor, I'm here.
So he is currently on probation?
Yes.
Okay, so I'm trying to for burglary by habitation. No? For what?
I'm sorry, go ahead.
What is he on probation for right now?
He is on probation for theft, and let me see what else.
Yeah, like a stolen car, 2,500 to 30,000.
Yes.
And he's been to placement.
Yes, sir, that's correct.
Okay. All right, Mr. Jackson, just so we can get on the same page, my general rule is when a kid, and this all happened, I guess when I first got here, my rule is when we try a kid with probation. If probation doesn't work, we look at placement. If placement doesn't work, then I look at TJJD. That's kind of the natural progress. So let me go over this. You're here because you're on probation. Police pulled over a car for a broken headlight. They smelled weed coming from the car, searched the car, found one of the kids in there with gun and weed. There are also 3 other kids in there that are currently under supervision by me in this court. And so I'm really concerned about kids that are on probation that are hanging out with other kids with guns and weed, with the smell of weed coming from the car, right? Because that would be a violation for probation. And if you are looking at a felony level offense and you've already been to placement, then the next step for you is for me to send you to TJJD, okay? So I want to go over your history with you. This all started when you're 10 years old and you're arrested for engaging in criminal activity. You're still 10. And now you turn 11, you have a theft of property of 50 to 500. Then you're brought in, arrested for burglary of a habitation at 11 years old. No, you're 12 now. So you're breaking a house at 12 years old. You got probation for that. Then while you're on probation, and this is all before I became a judge here, so it's kind of different philosophy. See, now you turn 13. Now you're still 12 years old. Now, while you're on probation, you get caught breaking into a car, and that probation violation. 5 months later, you have another probation violation. You turn 13, you get arrested for assault causing bodily injury, which your probation gets consolidated. and then we've modified and extended your probation out. Then now you're 14 years old, you're arrested for criminal mischief, which the DA supervisor cautioned. You're still 13. Now you get arrested for another burglary of a habitation, which you got probation for. How the heck did you get probation for the same thing? Oh, well, different judge. All right, so then you violate your probation 2 days. 2 days after you get arrested, you have your older probation is violated. Then July, you get arrested for theft of property, $2,500 to $30,000, so like stealing a car, which resulted in alleging you violated probation. And now you're 14 years old, and you get arrested for stealing a car, theft of property, $2,500 to $30,000. So you got probation and placement from that. Let's see. In April, you get another probation violation. May, another probation violation. You're still 14. You get arrested for criminal trespass, failing to ID to the police, which are a couple more probation violations than in January. So you're finally 15 years old, and you get arrested for assault, bodily injury, and theft of property, which the DA dismissed. And then in March of this year, so you are at this point, I guess 16, arrested for evading arrest, which the DA dismissed. And then another violation of probation, and then one more in September. And so we give you a drug test in November and you're positive for weed. And then now you are in a car with another kid with weed and a gun. Ms. Smith, did we give him a drug test today?
Yes, Your Honor. He was positive for THC.
Well, I said Ms. Smith, I meant Ms. Brown, I'm sorry.
Oh,
I'm sorry. All right, so, all right, Ms. Brown. Like my purpose of just is bringing these kids in with that car, just to talk to them, let them know that they can't be affiliating. Now that I'm seeing all this, why shouldn't he be in Kimbo? Why shouldn't he be in TJJD? Like, Ms. Brown, let me ask you this. Are you his direct supervising officer?
Yes, sir, I am.
Okay. So can you tell me, what has he done right on probation? Just one thing.
Well, since I received him on my caseload last month, from just a month of having him, he's been very respectful. He continues to meet with me accordingly. He keeps his visit. The last time I tested him, he was positive, which was on November 25th. Since then, we have started a drug curriculum with his therapist. But other than that, for the most part, he works with us. It's just we're trying to get the marijuana smoking out of the picture.
Well, and then break the new offenses too, right? Breaking the law.
Right, of course.
Getting arrested. So he has an A in attendance and he's failing everything else.
Yes, Your Honor, that's correct.
Damien, I'm just thinking of a reason, like you haven't done anything right other than be there and show up and be polite. And I'm trying to think of a reason why I shouldn't take you into custody right now and send you off and start the process and see if we need to send you off to TJJD. Like I'm looking for a reason. Like, Ms. Craven, any ideas? Ms. Craven isn't here. Sure. Ms. Brown, did he give an admission to you about the last time he used marijuana?
Yes, sir. He admitted to using marijuana on Christmas Day.
All right. So, Mom, where's he getting the weed from?
I guess he getting it when he be with the other children because he don't get it at home. I have no knowledge to him smoking until I get the result of a drug test.
Mom, okay, Mom, let's pause for a second, start over, okay? You cannot tell me you have no knowledge of him using weed until you get the drug test back.
Yeah, he don't come in my house like he's smoking or high or nothing like that.
He doesn't come back smelling like weed.
No, not in my house.
Your Honor, may I add? Mom works double shifts, so I speak with her over the phone and she meets virtually. But for the most part, he is at home with his dad and siblings. So mom is not there most of the time.
Damien, the one thing that is saving you right now is the fact that you're polite to Miss Brown. And I really like Miss Brown. She's one of the great probation officers. Like what she goes above and beyond is just, it's always impressed me. So Damien, this is where I'm at. The only thing saving you and keeping me from taking you to custody right now is the fact that you show up, you have an A in attendance, and you have an A in attitude. Okay, if it weren't for that, if you had an A- in either of those, I'd be taking you in right now. That being said, I think there needs to be changes, all right? You haven't dealt with me before, but things are different, okay? I take things very differently. I will not let you waste our probation officer's time. And so Ms. Brown and I haven't worked together that much, but this may be a process where she's understanding that I'm here, that if she tells me, just walks into the courtroom to say, Judge, Damien's just, his attitude's turned sour. He's still showing up, but his attitude's bad. I'll just bring you back here. It's not that hard for me. So I'm going to keep you in the community, but I'm going to put you on electronic monitor and you're going to be at home and you're not leaving the house because your mom is saying these are your friends that you hang out with. You don't need to be hanging around your so-called friends when they're rolling around in a car in violation of traffic law with a gun and weed in the car with weed smoke coming from the car. I'm also going to place you on the sweat patch. That means that is you know what the sweat patch is?
Yes, sir.
Okay. So it measures the oil coming out of your skin. You can't tamper with it, can't do anything about it. And we're going to keep that on there. And so if you use it all, we will know. And then I'm going to issue a warrant for you. Okay? So I am not taking you in right now, but this is a come to Jesus moment between you and me. You are either going to follow the rules or you're not going to follow the rules. If you're telling me you're not going to follow the rules, let me know now. We can start the process and we can figure out if you need another placement or TJJD. And that way, the sooner you get there, the sooner you get out. But if you want to play the game and waste everyone's time, you're only making this more painful for yourself. Right? Damon, do you understand where I'm coming from?
Yes, sir.
You have to understand when you ask this court for probation, you are saying you are going to get probation because you want one more chance that you can follow all the rules and do what you're supposed to do and take care of your business, right?
Yes, sir.
That's what you're asking me, right?
Yes, sir.
That means no weed, no hanging around other kids that are on probation or adults on probation or on DPP, no hanging around other kids or adults who are breaking the law. That's what you're asking me, that you can promise me that you're not going to do that, right?
Yes, sir.
Okay. I will give you that chance, and we're going to see with this EM and this sweat patch. But, you know, if you want to test me, hopefully you know about my reputation already, that I just don't play that game. Okay?
Yes, sir.
All right. Thank you, Damon.
Thank you, Your Honor.
Thank you, Ms. Brown.
Brown.
Corey Montague. All right, Mr. Montague, I'm Judge Kim. This is a detention hearing. Meeting for 10 days, so I'm reviewing your case, deciding whether to keep you or release you. If I keep you here, you have to see a judge every 10 days while you're here. You have the right to remain silent. You have the right to attorney. Good morning, Ms. Keenan.
Good morning.
All right, Mr. Montague, familiar with the case. It's the it's just a murder case. This is over the weed. Your level one outstanding. Wait a minute. Okay, level one outstanding since today.
He's actually been level one most of the time, Judge.
Okay. Mr. DeBose, did something happen? How far did he drop? Is Mr. DeBose here? No, is somebody covering for Ms. Bose?
Yes, sir. I'm here.
Oh, okay. Hello.
I was on mute. Sorry. Yes, Your Honor. He been a level 1-0 since the 28th, which is today. He went down to a 1A yesterday. kind of been jumping between a 1A and 1O.
Okay, good. Corian, I appreciate that. I know it's a lot of restraint. I know there's a lot of conflict back there. But this is, I'm glad you're showing me that you're controlling yourself. I'm deeply concerned about the severity of this case, especially the fact that it's a homicide, there's a gun involved. Not releasing you. I'm glad you're level 1 today, but this offense is just too serious for the protection of you and the community. All right? All right, thank you, Mr. Montague. Joseph Navarez.
Hello, sir.
Hello, Mr. Navarez. I'm Judge Kim. This is a detention hearing. You've been here for 10 days, so I'm reviewing your case, deciding whether to keep you or release you. If I keep you, you have to see a judge every 10 days. Mr. Adler is your attorney. You have the right to remain silent. Do we have a parent here for Mr. Navarez?
Yes, Judge. She's on Zoom.
On Zoom? Okay. Where's...
I'm right here, sir.
Okay. So, Ms. Holland, I've warned you twice, asked you twice to turn on your camera. You're refusing to do so. I'm removing you from this Zoom session. I don't know who the Sherry Tijani is. You need to be on the camera. You can't go and do chores while you're leaving your device logged into Zoom. It's just ridiculous. All right. Okay, Joseph, you're level 1 outstanding. You're 16 years old. All right, this is the this is in the stockyards, the robbery and the shooting of the off-duty Dallas police officer. And there's security footage showing that you were the person with the gun. All right, Mr. Navarez, and you were on supervision out of Dallas County. Mr. Navarez, again, as I told you before, whenever kids have guns and use guns, that gives me the greatest concern about releasing them. The fact that you were actually on supervision out of Dallas County when this all occurred, it just makes me even more uncomfortable. All right, so I'm going to go and detain you. I appreciate your level 1 outstanding. Mr. Adler, do we have any kind of prognosis on resolution for this case?
Judge, we were set for a certification hearing in December, but it got pushed back because Mr. Boneberg, one of his witnesses, was unavailable. So we're set for a cert hearing in January.
All right. So, Mr. Navarez, hopefully we'll get a resolution soon in the next couple of weeks when we have the certification hearing. Okay.
Yes, sir.
All right. Thank you, Mr. Navarez.
Thank you, Judge.
Thank you, Judge.
All right, Mr. Osborne. Yes.
Miss Holland just texted me. She said she was having problems with her service, and that's why she kept getting kicked off.
No, I'm kicking her off. It's
No,
not
no,
a
you
problem.
kicked her off. She said she couldn't get her video working, and that's why it wasn't on. She's requesting to join back.
I mean, I'll do it. Which child is she for?
It's for Judge Porter, Judge Riley Holland Stallings.
Okay. Well, if you could, I'll let her back in if she tries, but let her know that she needs to appear in person if she can't get her camera to work. Okay,
Yes, sir.
We'll do that next time. All right.
Your Honor, I'll be covering for Washington. This Osborne with his sister. Grandmother is currently ill. He was placed with CPS custody to grandmother, but she's currently ill.
Who was placed in CPS custody?
Osborne. He was lived with his grandmother through CPS, but she's ill.
Okay. All right. So, Osborne, I'm Judge Kim. This is an out of custody hearing. I'm deciding whether to take into custody to release you or to keep in the community. if I take you in custody, you'll see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. We've appointed Mr. Berger as your attorney today to answer any questions you may have. All right, so Osmond, I remember you because we've dealt with each other quite a bit. You're 15 years old. Start when you're 11 with an assault case the day before your birthday. You turn 12. Then you have no, you were 10 the day before your 11th birthday. You turn 11, you have a theft case. 5 months later, you become evading arrest. 2 months later, you get picked up for criminal trespass and for fail to ID. 3 months later, arrested for assault, bodily injury. Then evidently you behave for 8 months. Then you get arrested for theft of a firearm, which you got probation for. At that point, you're only 14 years old. Then 8 days after you are, I guess we released you on the theft of a firearm case, you picked up a marijuana case, an unlawfully carrying a weapon case, an unlawfully carrying a weapon on an alcohol premises. Then, well, you turn 15, get arrested for evading arrest. You get out. 2 days later, you're arrested for evading arrest again. You get, let's see. So now you're caught in a car with another kid who has a gun and weed, the smell of weed coming from the car with 3 other kids. You test positive for weed, as does everyone else in the car. So who's covering for Miss Washington? I didn't hear.
I am, Your Honor.
Okay. All right, Mr. Colbert. So tell me, what has Osmond doing right on probation? Like anything?
Your Honor, we had administrative hearing on November the 18th here recently due to the fact of some information we received that he was located. There was a shooting that took place. However, he wasn't shot, but he did get hurt while running from the location. Grandmother at that time did not know where Osborne was located. We was having some issues due to the fact of his safety with TCAP. TCAP went to pick him up, Your Honor, to provide some services. However, we had, like I stated earlier, we had an administrative hearing to try to establish Klein was leaving home without permission with grandmother. Grandmother just asked for where, she said she was okay with him going, but she wanted the location and who he was leaving with. We addressed that issue, Your Honor, and since the administrative hearing, he has been compliant with, picking up the phone and calling his probation officer due to the required contacts due to COVID-19. He did test positive, Your Honor, on the 18th of November for marijuana. We did submit a substance abuse assessment referral over to the recovery center to get a substance abuse assessment schedule.
Did we give him a UA today?
That is correct, Your Honor. UA today. He did test positive for marijuana on this date as well.
So, okay, so again, and if you don't know, because this isn't your case, but what has he done right on probation? Like I'm still, like everything you just told me about how you're trying to fix problems that he did wrong. What has he actually done right?
Your Honor, it's, I would say, Your Honor, due to the family dynamics in the home, there's been some issues. And I think that that has played a big part in Osborne making positive choices. We're actually, definitely trying to engage him in, the proper programs to get a deterrent of his behavior.
So, Ms. Corbett, I'm gonna put you on the spot here. When you say positive choices, what positive choices is he making? I'm trying to figure out, like he was just popped with a UA, tested positive a month ago, and now he's continued to use marijuana. Like what positive choices is he making? And if you don't know, Mr. Colbert, this is like, I understand this isn't your direct supervision case. So if you don't know, you don't know. I'm looking for anything. Like any reason, just one reason, so I don't have to take him in custody. Mr. Berger, looks like your client wants to say something. I don't know if that's the wisest thing or not.
I'll let him say something, Judge.
All right. Yes. So Osmond?
I want to say, I had, like he said, after the administrative hearing, I started making all my phone calls. I started doing everything right. This is the good thing that I've been doing after administrating here. I haven't had no problems.
Hold on. You said doing everything. Smoking weed.
No.
You say I haven't had any problems. Smoking weed is a problem. You can't be on probation smoking weed.
Yes, sir.
All right. So let's walk it back and tell me what you've done right.
I started making all my calls to my probation officer in TCAP after the administrative hearing.
Osmond, what you have to understand is the whole reason why we're talking today, you wouldn't have even been on my radar. The whole reason why we're talking today is you decide that you're getting in a car with other kids that are on supervision, another kid with a gun and weed. I mean, if you had not gotten in that car, you and I would not be talking today. You understand how your friends, your so-called friends, are dragging you down? It's not that they snitched on you. You're making the poor choice to even affiliate with them. And that's why you're in this situation. That is why you're sitting there uncomfortable thinking, what is the judge going to do to me? Because now I got busted smoking weed. We wouldn't have had that UA today if you hadn't been in that car. You see how this all relates back to who you affiliate with?
Yes, sir.
You can either surround yourself with people that are going to lift you up and put you in a better spot, or surround yourself with people who are going to drag you down. You know how easy it would have been for the police to put the weed on you or the gun on you?
Yes, sir.
I mean, the police could have easily said, you know what, we got this kid with the weed and gun, so why are we going to put this kid from Louisiana, Keith? Why are we going to put 2 cases on him? Let's just put 1 case on him and 1 case on Osmond. Because Osmond's already on felony probation. Right?
Yes, sir.
And just because you can beat the rap doesn't mean you can beat the ride, right?
Yes, sir.
All right, so Osmond, this is where I'm at right now. I want to give you the chance to do right. If your attitude is right, if you're making your calls, if you're reporting like you're supposed to, that's what I need. Because as long as you're doing that, then Ms. Washington, Mr. Colbert, then we can do things. We can make progress. So I'm gonna keep you out in the community at home. I'm gonna put you on the EM. I'm gonna put you on a sweat patch. Do you know what a sweat patch is?
No, sir.
A sweat patch is just this, is basically a sticker we put on your arm, and it traps the oil coming out from your skin. You can't do anything about it. If you use any kind of drugs, that comes out, that gets absorbed into the patch, and we send that patch off to the lab to get tested. It is 24/7 monitoring. If you're around other kids that are smoking weed, it is possible for you to absorb enough for it to come out of your sweat patch. You need to stay clear of everyone who is using drugs, all right? You cannot trick the sweat patch. It is 100% foolproof. But you know what? It 100% sets you free. So that way, if you're in a situation where one of your buddies gets arrested and the cops put the weed case on you, you can say, Judge, test the patch. I'm not using weed. The patch will set me free, all right? Use it to your advantage to prove to me that you're staying clean. Because you know what, Osmond, when you're on probation, what you're telling me is that you're asking for that second chance. You're asking for me to give you a chance, but to get that chance, you're promising me you're not gonna use drugs, you're not gonna associate with other people who are on probation, right? And you're not gonna break the law, and you're gonna do what you're told. That's what you're asking me for, right, on probation?
Yes, sir.
I'll give you that chance. But now, right, you're on my radar, okay? So we're gonna lock you down at home for now on the EM, and we're gonna put that sweat patch on you, and we're gonna make sure that you're not using any kind of illegal substances, right? Given the situation when you came in here, Osmond, I think I'm being pretty fair to you, aren't I?
Yes, sir.
Because you understand, just being positive for weed alone, not today, but back in November, that would have been enough for me to bring you in. The fact that you're associating with other kids in that car with a gun and weed, that's enough for me to violate probation. You understand that, right?
Yes, sir.
I'm giving you another chance, but this is based on your word as a man. Are you giving me your word as a man?
Yes, sir.
Okay. Now, if you want to act like a grown-up, I'm going to treat you like a grown-up. If you want to act like a kid, I'll treat you like a kid. Stop making grown-up decisions, okay?
Yes, sir.
Those people you're in the car with, are those people your grandma would have approved of?
I've been no, sir.
No, come on. Grandma would not let you in a car with a kid with a gun from Louisiana, right?
Sir.
Okay, so that's what I'm talking about, is make these decisions based on what you think is the right thing to do, not what you want to do. Fair enough?
Yes, sir.
All right, so I'm gonna leave you in the community. Don't let me down, all right? You're asking me for this chance, right?
Yes, sir.
Okay, let's do it, Osmond.
Thank you.
Thank you, Judge.
Thank you, Your Honor.
All right, Danny Parker.
Your Honor, I'm covering for Mr. Kroll today.
All right, thank you, Ms. Lewis. All right, Danny, I'm Judge Kim. This is a detention hearing. You've been here for 10 days. I'm reviewing your case, deciding whether to keep you or release you. If I keep you, you have to see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. Your attorney, Mr. Houston, I think. Mr. Houston, Dwayne, are you here?
Yes, sir, I'm here.
Good morning. All right, so, see, do we have a parent here for Mr. Parker?
I attempted to call mother this morning, got a voicemail, and sent her the Zoom link about 10-ish. Her name is Miss Padron. I don't see her on here, but I wouldn't recognize her.
Okay, so I don't think we have a parent here. All right, so Danny, this is the one. You're on probation. You're living in Abilene. You ran away, found your way back here. You're on probation for having a gun. Find your way back to Fort Worth, Tarrant County, and you were caught in front of a convenience store by the Fort Worth police surveillance cameras with another gun. So I'm afraid if I was to release you, no matter where you got released to, you would find your way back to Tarrant County, get yourself another gun. And so I'm detaining you for the safety of yourself as well as the community. Thank you, Mr. Parker, or Mr. Parker. All right, we have Lewis Parker. Lewis Parker. All right. You know the drill. It's a detention hearing, 10 days. Got to review your case, decide to release you or keep you. You have the right to remain silent. You have a right to an attorney. I believe your attorney is Mr. Hall. Mr. Hall, good morning.
Good morning, Judge.
All right. So I believe I released you right before Christmas. Spent some time with your mom and your dad. Is that right?
Yes, sir.
Okay. Mr. Parker, you understand how I am frustrated that you've been here, but you understand why I've been keeping you here, because when I let you out before, because you had been here for so long, you got picked up with a gun. So I'm just really worried. I've let you out a couple times. I'm trying to foster a relationship with your dad since he's just recently released. Okay.
Yes, sir.
I think your dad was here trying to get on Zoom. Dad, are you here?
He's on.
All right, there we go, Mr. Parker Sr. Did you have share some good time with your son?
Yes, Your Honor, I did. Thank you.
Yeah, no, I regret that young Lewis Parker has had to be here for so long during this case. I hope you understand the situation that I'm in.
Yes, sir.
And Judge, I think they've extended his working with the MHMR people on the restoration program.
Okay. 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 No, I'm glad that's going well. All right, so Lewis, I'm going to detain you. I mean, you knew I was going to detain you. What do we have coming up? Do we have birthdays or anything coming up?
Not until February 1st is his birthday.
Is his birthday?
Yes, sir.
All right, Lewis, let me see you at the next 10-day hearing, and we'll go from here. Okay, you're level 1-0. You're doing your part. I'm glad you are. I appreciate it.
Yes, sir.
I hope you understand just how serious this offense is. All right, that's what's causing me the concern. Okay.
Yes, sir.
All right, Lewis Jr., do you have any questions for me?
No, sir, Your Honor, I don't.
All right, I'm sorry, Lewis III, do you have any questions for me?
No, sir.
All right, thank you.
Thanks, Judge.
Thank you.
Thank you, Mr. Hall. Okay, Hugo Reyes. Boca Sangre. All right, Mr. Reyes, I'm Judge Kim. This is a 10-day detention hearing. I'm deciding whether to keep you or release you. If I keep you, you have to see a judge every 10 days while you're here. You have the right to remain silent. You have the right to an attorney. Mr. Adler, your attorney is here. Good morning, Mr. Adler.
Good morning, Judge.
All right, so this is about you're on probation for deadly conduct and aggravated robbery. No, he's not. He had pending cases. Yeah, for aggravated robbery, deadly conduct, cut off his monitor, or no, he ran off in violation of his monitor. Right, and this is where he had the pistol, shot at the victim, allegedly. And oh yeah, so this is the one, he violated his monitor, police went out to get him, he ran from the police, and then he was just a jerk to the police, kept on unbuckling his seatbelt, so they gave him a no seatbelt ticket while for doing that on the way to Kimbo. All right, Hugo, I just think you can't be supervised right now, so I'm gonna go, you're level 1 acceptable. Why did you drop down in levels, Ms. Guerrero?
According to JC Message, it just says he lost points from both shifts on the 27th.
Yeah. So your attitude, Hugo, obviously your attitude is not getting any better. So I don't feel comfortable releasing you into the community because you'll just have that attitude at home too. So I'm going to go ahead and detain you. Thank you, Mr. Pocasangre. Hugo Ramirez.
Yes, sir.
All right, Mr. Ramirez, I'm Judge Kim. This is a detention hearing. The purpose of this hearing is for the law says when a kid's brought in, you have to see a judge within 2 business days. I have to decide whether to keep you here or to release you. If I keep you here, you have to see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. Mr. Adler has been appointed as your attorney. So, Hugo, you've never been here before.
Okay.
On the day after Christmas at 4:40 in the morning, police were dispatched to a burglary. The doorbell camera alerted the owner that somebody was looking through the window and then entered the home when no one was there. Police found you and a companion walking away from the home, and you matched the description. Evidently, you ran from the police and were detained a short time later. The companion seemed to have gotten away. So there's a broken window with blood on it. They cleared the house and saw a gun safe that had been rummaged through. The police reported that he saw Hugo on the camera outside the house carrying a rifle case with a rifle inside. The rifle was located on the side of the house. Oh, Ms. Rojas, so the rifle was from the home?
Yes.
Okay. All right, well, Hugo, I have a big problem with kids that break into houses, but do we have a parent? We have parents here.
Yes.
All right, but I have a bigger, do the parents understand English?
No, Your Honor.
No, okay. So I have a bigger problem with kids with guns. All right, that's my absolute, now, it may have been that you ditched the gun, but the fact that you're willing to pick up a gun gives me great concern. I generally do not release kids anytime a gun is involved until I'm comfortable releasing you back to the community. I don't know how many guns that you have in your possession. I'm worried about you going out and getting access to other firearms. So I'm going to detain you at this point. We'll see how you do in detention. I'm open to the idea of releasing you, but at this point, I'm just very concerned. So, Ms. Rojas, if you can explain that to the parents later on, just my policy and they understand.
Okay. Señor, lo van a detener ahorita en unos minutos. Si me puede esperar en la sala de espera, le doy la razón de por qué el juez está deteniendo al niño. Okay.
All right, thank you. All right, we have Alexis Soto.
No.
All right, Mr. Soto, I'm Judge Kim. This is a detention hearing. You know, you've been here before, you know the drill. When you come in, you have to see a judge within 2 days. I have to decide whether to keep you or release you. If I keep you here, you see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. Mr. Adler is your attorney. Do we have parents here? There they go. They're coming.
Yes, Judge, Mom is here.
Okay. All right. Hello. She does not speak English, correct?
Correct, Judge.
All right, Ms. Rojas, if you can interpret, tell Mom hello for me.
Señora, el juez dice hola.
I'm going to ask if she's tired of seeing me yet.
Dice si ya está cansada de ver al juez.
¿Dónde?
Si ya está cansada de ver el juez.
No.
She
She's
says,
not tired. She's not tired of coming here.
dice que si no está cansada de viniendo aquí tantas veces.
Pues por Alexis, pues sí.
Yes, for Alexis, yes.
Poor Alexis. Poor Alexis. All right. So, Alexis, currently you're not. You were on probation from April of last year. I guess you finally finished your probation. You had like 1, 2, 3, 4 probation violations. We have to keep on issuing warrants for you. Now you got pending cases for theft of property, September 10th, criminal trespass, September 24th, with the burglary of a building. So you have pending cases. Yesterday, police were dispatched for a weapons call. Police got there, they saw you matching the description the witness gave. They said you had a gun and pulled the slide back. When you saw the police, you took off running and were detained. They did not find a weapon, but you made a statement saying it was a pellet gun. You tossed it in the park and later asked police who saw him with a gun. The gun was later found underneath the vehicle. It was a 9mm handgun with 9 rounds in the magazine, and you tested positive for marijuana when you came in. So, Alexis, I don't think you have had a gun charge with me before, but you have to understand that whenever a kid has a gun, that gives me great concern and hesitation. And so I generally just detain all kids that have guns until I'm comfortable releasing you. It also looks like you're escalating your crimes. It's getting more and more serious and more dangerous. So the path that you're leading, I hope you understand, is leading straight to TJJD and ultimately TDC, adult prison. So at a certain point, you're going to decide that it's not worth it. It's not worth it. You don't like seeing me. But at this point, I'm detaining you. We'll see you in 10 days to see what your behavior is like. And I'll make a decision then. All right. Thank you, Mr. Soto. All right, Davion Stevenson. All right, Mr. Stevenson, I'm Judge Kim. This is a detention hearing. See, your attorney requested this hearing. I'm deciding whether to keep you here or to release you. If I keep you here, you'll see a judge every 10 days while you're here. You have a right to attorney. Mr. Graham, I believe I saw him earlier, is here. And you have the right to remain silent. So, Mr. Graham, for what purpose did you request this hearing?
Judge, at our last detention hearing, he was level 1 outstanding, but only for a short period of time. Judge Porter said if he would stay on, we would be able to get him released. I tried to get him on last Wednesday's docket, but just through email and other stuff, we missed that and he got set for today. So we're asking for him to be released. I believe he stayed on level 1.0 is the information I have.
Yes, since December 18th. Yeah, this was a aggravated robbery. Yeah, it was a gunpoint aggravated robbery with women in their car. Even though it's level 1.0, I'm not comfortable releasing him. I'm just, the level of this crime is so serious. I know it was a pellet gun with a real magazine in there, but this is just so serious that you were willing to make somebody fear that they were about to die.
If I may interject.
Yes.
He was not identified at the time. He was with another kid some 4 hours or so later. Even based on probable cause, I think it's a weak case, but it's likely to be set at trial. There was nothing that identified him anywhere near the scene of the car. A kid he was with some number of hours later had a backpack that related back to the original offense, but he was not in any way identified back to the original offense.
Surveillance cameras averted 2 black males, Davion and a companion, enter the stolen vehicle. Davion taking the driver's seat, and then companion taking the backpack.
Yeah, the backpack is what identified, or police believe linked the other kid back to the original offense. But where they're in this car, that's, as I recall, 4 or 5 hours later.
Yeah, but the law of parties, right? I mean, this is Mr. Graham. Like, we've been colleagues for years, right? So I'm just.
Well, no, I get that, Judge, but there's nothing saying he was with the other kid 4 or 5 hours earlier at the original offense.
But isn't law of parties if you plan, commit, or benefit from the offense in conjunction, that it all can relate back to the actual crime itself?
It can, but there's none of that there.
Other than he's in the stolen car.
Well, he's not charged with the stolen car. That would be a separate offense that he's not charged with.
Well, I guess.
Offense he is charged with, there's nothing that says he was anywhere near or identified being there 4 or 5 hours earlier.
Well, okay, so, and I like literally like, this is, I want the discourse. I'm trying to figure out. But if it's so let's say it's a bank robbery. And if I'm caught with the cash from the bank robbery, even though I wasn't at the robbery itself, I've still got the bank robbery charge, right?
That's correct, but he wasn't found with anything related to the original robbery is the point.
Wasn't the car stolen in the original robbery? Or was it a different car?
Well, the other kid and the backpack was there originally. If that kid comes, say hypothetically, and picks up my kid afterwards, and my kid had no idea what had happened 2 or 3 hours or 4 hours earlier, then no, even by the law of parties, he's not part of it.
But he was a driver. I mean, he was driving the car, the stolen car, which is the fruit of the robbery. I'm trying to figure out, like, earnestly, I'm trying to figure out if I'm missing something. Like,
well, Judge, he still has to know that it's the fruit of the robbery to charge him with the robbery. Now, if they want to charge him with unauthorized use of a motor vehicle or something related to the car, that would be a different question. But even under the law of parties, he still has to know something occurred 4 or 5 hours earlier.
Davian, do you understand what's being said?
Yes, sir.
You understand? So you understand that, like, really where Mr. Graham and I'm just not in disagreement. Like, we've had great conversations for years. Like, I've known your attorney for years and years. And so the sticking point on this one is, even if you knew or didn't know the car was taken in the robbery, right? That would be the difference between you being guilty or not guilty of stealing the car, right? But the hitching point for me is something called probable cause. Is the way it's spelled out, would a reasonable person think that if you're driving that stolen car a couple hours after it was stolen at gunpoint, would there be probable cause that you actually were part of stealing the car, right? You understand how this is all relating back to, it could be wrong place, wrong time, but that keeps you akimbo, even though you may not get convicted at a trial. You see where this is going?
You see.
Okay, I just want to make sure you understand what. Yes, Mr. Graham?
That wasn't me, Your Honor.
Oh, okay, I'm sorry. Yeah, I want to make sure your client understands, like, the discussion.
I learned my lesson not to get nobody cars.
Hold on, I don't want you talking about the car. Your attorney doesn't want you talking about the car. This is, I don't want, you got a hearing coming up on January 8th, right? So, yeah, Mr. Graham, I'm not comfortable, especially I'm going further down the offense report. The surveillance video clearly shows Davion and his companion getting in the car. Companion had the backpack, but the police asked him about the backpack and they both said they didn't know anything about a backpack. Like, if he was more forthcoming, it may be different for me. But the fact that he's trying to conceal it or avoid any kind of responsibility makes it seem like he's really trying to avoid culpability. Just kids with guns, that just really gets me. I mean, that's, yes, this. Mr. Lewis, his behavior level now is level 1-0. How far did it go down?
Never dropped before 1A, I believe. I will double check that just to make sure that my memory is correct.
Do we know the companion's name? Oh, Jay Morrell. Mom, who's Jay Morrell?
I think it's his friend.
Your Honor, if I may.
Yes.
It's Jacoby Morrell. He just received probation the other day.
For this
Last week.
offense? So did he make any admissions about Davion?
No.
He actually did receive one confinement in November.
So, Ms. Paxton, when he was adjudicated and received probation, this is Jacoby Morrell.
Yes.
Like, there's no part of the stipulation that mentioned who the other party was at the robbery?
I believe there was. I still have the files sitting in front of me.
Okay.
Well, I don't have a copy of the stipulation agreement, so I don't know for sure, but he was ordered not to have any contact with Mr. Stevenson. So I don't have the stipulation agreement though. I don't remember who the DA was. Let me look real quick. Alex Haynes is the DA.
Yeah, Mr. Graham, I'm just not comfortable yet. These kids with guns issues, it's just too big of a deal for me. Yeah, the next court setting is January 8th. Are we? It's set, Mr. Graham, it's set for adjudication dispo. You're saying that you do not expect it to go? Like this is going to be a trial?
That is correct, Your Honor.
Let me look into a little bit more, figure out what's going on. At this point, I'm not comfortable, but it seems like he's behaving himself back there. So that's keeping me optimistic about releasing him. But it just takes a lot for me to be comfortable whenever a gun or even a fake gun is used in the commission of a crime. All right. So, Mr. Stevenson, I'm going to go ahead and detain you. It's just, this is based on, being around guns. All right. So, all right. Thank you, Mr. Stevenson.
Sir, excuse me. You told me that last time. You said next time when I have you, just when I get released. If I'm when I stand.
So I rarely, well, I can tell you now for an aggravated robbery case, I've never promised somebody get level 1 and you're released. I always say, we'll see. If it's like a weed case or a family violence or stuff like that, I say that all the time. Get to level 1 and you get out. But not for an aggravated robbery. There's too many variables coming in. The last thing I want is for a kid to be out there with an airsoft gun or a BB gun and somebody has a real gun and shoots the kid dead. That's what I'm afraid of when it comes to the idea that somebody can make somebody else afraid that they're going to die on the spot and get shot. That's what we all deserve to live free in society where we don't have to fear getting killed.
But I learned my lesson.
Well, and you may have, but you have to understand, I see a lot of kids come in and out of here and every one of them says they learned their lesson. Not everyone has.
I'm different from them.
Well, yeah, every kid says they're different too. Right?
How does Fred Jacoby went home?
How did what?
How does fair that Jacoby went home and I'm not getting released?
How's it fair that Jacoby went home?
Yes, sir.
Oh, I mean, every case is different, right? Jacoby may have just taken the probation right away. He may have done it. You may not have done this. I'm presuming that you did not do this. I'm saying that I think there's probable cause that you did this, but there may not be enough to actually find that you did it. And so you have the right to a trial. You deserve the trial, right? So, I mean, every case is different. I can't compare everything identically the same. Okay. So, but this hearing is not about whether you did it or not. This is about whether it's safe to release you to the community or not. And I'm not comfortable that it's safe to release you to the community.
So you was comfortable to let him go?
No, he's on probation. I didn't let him go while the case is pending. He's on probation.
Can I get released on probation too?
Well, that's something you need to talk to your attorney about.
Well, can my attorney give me a call?
Yes, Dave, yeah, we will discuss all of that.
Okay, all right, thank you. Xavier Funches. Oh, it's Judge Porter. Okay, yes, at this point, I can turn this docket over to Judge Porter, and then I'll be back for some of the under 14-year-olds. Thank you, everyone.
Good morning, everyone. Hey. Are you Mr. Austin?
Yes, sir.
Excuse me. Mr. Austin, my name is Judge Porter. Mr. Austin, my name is Judge Porter. Can y'all hear me okay?
Yes, sir.
Thank you. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Shoemaker, is here. He was earlier.
I am, Your Honor.
Thank you, sir.
And just at the appropriate time, I have some information when the court's ready.
Okay. Ms. Guerrero is here. There she is. All right. Have we had a supplement provided by the Fort Worth Police Department regarding the underlying alleged offense?
Judge, I know that some information was given to the district attorneys. It was the media. So I don't have access to view that media. Because that's the only thing that was written in the supplement, that it was media information.
Okay, Mr. Reed, what can you shed light on regarding the underlying facts of the offense? Is there anything to actually link Mr. Austin to the robbery? Because Judge Kim noted that there was a probable cause problem last time. Have you received additional evidence that fixes that problem?
Judge?
Did not know that was an issue that would be addressed at the detention hearing as far as probable cause. I'd be happy to look into it and report back to the court.
Ms. Guerrero?
Judge, I do have the stills that were sent to me by the FBI. There's stills of Mr. Austin inside the store and then a picture of him at the patrol car. And by the clothes that he's wearing, I can tell you that that's him in the stills inside the store.
Okay. All right, Mr. Shoemaker, what are your thoughts?
Well, Judge, just simply, I think that these offenses, there were numerous offenses committed by adult participants in this, in which Mr. Austin was not a participant. Mr. Austin is if he was to be released, would be released to a Sherry Cole, who is with us today. She is an aunt. She lives in Rowlett, and that we would ask that he be released to her with electronic monitoring.
All right. Based on the additional evidence, Ms. Guerrero noted for the court will find the probable cause to exist to link the respondent to the alleged delinquent conduct, sufficient to believe that there is probable cause to believe that the respondent is engaged in delinquent conduct. I will find probable cause. I will also order that he continue to be detained, and we'll review this in 10 business days. Thank you, everybody.
Thank you, Judge.
All right, Denali Dunbar has waived. So Lucas Fry.
They keeping him.
Are you Mr. Fry?
Yes, sir.
Mr. Fry, my name is Judge Porter. I think we've met before. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And Mr. Sierra, your attorney, is here. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your detention in our facility. The purpose of this hearing is to determine whether you should continue to be detained or released to a parent or guardian. Mr. Fry, what is your level in the back?
2.
What is it supposed to be before I can consider your release?
1.
What do I need to do today?
Detain.
Why?
Because I'm not a 1.
All right. What do you need to do to get to level 1-0?
Not get in trouble.
There we go. All right, thank you, sir. That'll be the order of the court. Thank you, Mr. Sierra.
Yes, Judge.
All right, Ms. Guerrero, help me pronounce the next name correctly.
Jordan
The last name.
User. And his
Repeat.
parents are
Pardon?
User.
It's
Usler?
Facilier.
Yes.
Ah, thank you, Mr. Ferguson. All right. Are you LaJordan?
Yes, sir.
Sir, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Ferguson, is here. Ms. Guerrero, what were the results of his UA on December 15th?
He was negative, Judge.
Okay. What's his history with the department?
He is pending a petition, Judge, for the criminal trespass and the evading arrest, but he's also pending a petition in Dallas County. That's the reason we had the out of custody that he was detained on.
And what is, what's that Dallas County offense? Do we know?
Yes, sir. If you'll give me 1 second, I'll get that for you.
It's evading in a vehicle, Judge.
All right.
Yes.
Thank you, sir. All right. Mr. Reed, what are your thoughts?
Or the state would ask that the respondent be detained as he's a threat to the community, having both charges here in Tarrant and Dallas County.
All right. Mr. Ferguson, what are the dates of the Dallas County charges? Allegedly?
I'm not, it was after this case. But if I may, Judge, basically what happened, he was brought in for out of custody because Dallas sent him home. But then he was brought in out of custody. Judge Kim was actually, if he had passed his UA, was going to release him.
And what happened?
Just some attitude issues with his mom. And so Judge Kim kind of put him in and said, look, you're having issues at home. He had some issues in the hallway. I actually was gone, so I didn't see it. But so it was sort of a show me that you can behave well in detention, and then we'll talk about you behaving well at home. And so he's been in for the last 2 weeks, and we were going to kind of see how he behaved. So I would like, I think he did fine, right? I'm not 100%, but
he's been level 1-0 since the 18th.
Right.
And Judge, the offense in Dallas County happened on the 15th of December.
So I would ask that he go home. If you want to put him on a monitor, that's fine. He was on one before and he did really well. And that's where we're at. So.
Well, did really well except for picking up the new offense in Dallas County.
Well, that was after it was taken off.
All right. Are you mom in the parents' room?
Yes, sir.
Mom, what are your thoughts?
I would prefer for him to be home, and if y'all send him home, I would prefer for him to be on the monitor. That way he don't have to worry about going nowhere.
Okay.
Because he do fine in my house.
Where was he back on the 6th of December? Whose house was he living in?
He was over there.
Okay. And whose house was he living in September of this year?
Grandmother.
He was with my mom.
Okay.
Judge, he also has court in Dallas County on the 4th of February.
But we have him scheduled for court on the 11th.
On the 11th. Yes, correct.
Mom, he was allegedly found with a Ruger handgun in Tarrant County. Where did he get the handgun?
That's my first time hearing it from you. I don't know nothing about that.
You have no idea where your son would get a handgun.
That's my first time hearing it from you right now. I was never told nothing about a gun.
Okay, that didn't answer my question. My question was, Mom.
No.
Okay. Does grandmother have handguns in her house?
No, she does not.
What about your other relatives?
No, they do not. Jordan don't go nowhere if it's not with me.
Well, except he was out before 7 in the morning back at the beginning of this month.
He was in his dad's custody.
Dad, where'd you get the handgun?
I have no idea. I dropped him off to the mall. He was supposed to call me to pick him
At
up
7
from the mall.
o'clock in the morning?
No, the night before. He didn't call. He went his separate way.
So he ran away the night before?
He was supposed to call me to pick him up. He didn't call.
Did you call the police to report him as a runaway?
No, I did not.
Why not?
He done it several times before.
Okay. I'm not comfortable releasing him at this time, so I'm going to order that he be detained. I believe that if I were to release him today, he would be a danger to the community. That's going to be the order of the court. Thank you, Mr. Ferguson.
Thank you, Judge.
Right. Well, Jordan, I'll call you. All right.
All right. Riley, my name's Judge Porter. We've met before. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Adler, is here. I am personally familiar with this case. The court has previously found that probable cause exists to issue a directive to apprehend for a violation of your probation or an alleged violation, one or more, of your probation. Mr. Adler, what are your thoughts?
Your Honor, the mom was on here earlier, and then is she on?
Yes, she's on. Ashley, if you'll go ahead and start your unmute. There we go.
Can you hear me?
We can.
Okay.
Go ahead, Mr. Adler.
Judge, if it may please the court, there was a huge family dynamic between Ms. Holland and Riley. I don't know if anything's been resolved since we last met or since she last talked to Mr. Miller, who's doing a good job in this case. So I'm truly going to defer to them two and see what they have to say regarding how the relationship is going between mom and son.
Mom, have you had a chance to talk to Riley while he's been in detention?
Yes, we've done counseling sessions with Nia, his counselor from Lena Pope, which we love. I have not gotten to speak with Amanda that much. She got kind of homebound again. She was due to come out when Riley ran off. So, but we are continuing with Nia and hope to continue if you decide to send them to TYRC.
Well, if I decide to send him to TYRC, that'll be at a hearing on his motion to modify. And I'll allow Mr. Adler to schedule that at an appropriate time.
Your Honor.
Yes, Mr. Miller.
TYRC did agree because we were not planning to file the VOCO at this time. We built it because of the DTA. We had an agreement with TYRC once he completed his 14 days of quarantine that they had a bed available and they were willing to pick him up today and transport him there. And then once he completes the program, him and mom currently reside outside of the county in Parker County. And we were going to release him to that.
But that was inpatient at TYRC?
Yes, sir.
Okay. We probably need to have a hearing on that because he's currently on probation. And if you go from just straight probation in the community to an inpatient treatment, I consider that an increase in the level of confinement. And he has certain due process rights that we need to make sure he's been afforded before we make that order. Now, Mr. Adler, I'm here all day. So, you know, whenever if you want to do a hearing today, I'll make that amenable to you. But I don't think I can just flat out.
I understand what you're saying. And if Mr. Reed is listening in, I think we'd have to get the DA on board and see what their thoughts are. So I'll try and have a conversation with Mr. Miller and whoever the assigned assistant district attorney is today, Judge, and see what we can do at least today or tomorrow.
That's fine. Just
thank you.
Let me know.
Okay.
But Riley, as for now, based on your history, I think that if I were to release you today, you'd be a danger to the community. So I've got to order that you be detained. Thank you, sir.
Thank you, Judge.
All right, Mr. Murillo. Okay, the person who is in Moto E5 Cruise, I need you to pull your vehicle over and park it immediately. This is considered a court setting. It's not an opportunity for you to drive around. Also need you to rename your screen name to your name so that we know who you are. I'm going to give her 30 seconds to accomplish that. If it's not accomplished within 30 seconds, I will remove her from this hearing. All right. Are you Mr. Murillo?
Yes, sir.
Mr. Murillo, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Beaver, is here. You've been level 1-0 since the 15th of this month. So I'll let Mr. Reed speak first. Mr. Reed, what are your thoughts?
Governor, I was trying to coordinate with Mr. Adler.
All right, then I'll let you do that, and I'll let Mr. Beaver give me his thoughts.
All right. Thank you, Ron. We would request that Mr. Murillo be allowed to go home. I believe that both his mother and I know that there's another family member there in the family courtroom. But when I spoke with her earlier this morning, she assured me that she'd be able to make sure that Manuel stays on the straight and narrow if he goes home.
Well, I'm looking at his history, and he's been in and out and in and out and in and out, in and out, in and out, in and out of Kimbo over the last year. I think if memory serves, it's like 5 times at least. Am I getting close, Ms. Lopez?
Yes, Your Honor. And I would like to mention something to the court that I spoke to him in detention face to face, and I am concerned, and I spoke to Mother earlier today, that he doesn't seem to understand what he's doing is actually wrong.
I tend to agree based on his in and out, in and out, in and out.
Yes, I truly do feel that he just thinks, I mean, he basically said the car was there and I took it. I mean, that's just a complete disregard for the law and respect.
Mr. Beaver, he's been level 1-0 for 13 days, and that speaks really well. But the last 12 months, he should have been level 3 confined for his behavior. And I've got to weigh 12 months against 13 days. And right now, I'm afraid that based on his history, if I were to release him, he would be a danger to the community. And I'm not convinced yet that he can behave himself in the public yet. So I'm going to order that he be detained.
Thank you, Your Honor. Mr. Murillo, I'll speak with you. I'll give you a call today.
All right, Marion Perry. I know Mr. Green was here earlier. There he is.
Come here, sir.
I'm here, Your Honor.
All right, are you Mr. Perry?
Sir?
Are you Mr. Perry?
Yes, sir.
Mr. Perry, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Green, is here. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your detention in this matter. Mr. Perry, what is your level in the back?
1A.
What is it supposed to be before I can consider your release?
1O.
Okay, and so because you're not 1O today, what should I do?
Detain me?
Yes, sir. And why?
Because I'm not on 1O.
Yes, sir. What are you going to do to get to 1O so you're in a better situation next time?
Control myself next time.
Okay. All right. Let's make it happen. Thank you, sir.
I believe we're set for court next week, Your Honor.
All right. Then I will see y'all then, Mr. Green. Thank you.
Thank you, Judge.
Thank you, Judge.
Find HPOD. There we go. The person who has labeled herself as Moto E5 Cruz, I need you to go in and rename your screen name to include your name so that we know who you are. This is your last warning.
Judge, that's the parent for our next hearing, and I was informed by Ms. Aguirre that she's not familiar on how to do that.
She doesn't speak English.
Thank you, Ms. Saldana. How are you today?
I'm fine. How are you doing?
Okay. Ms. Saldana, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge within 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Rafael Sierra, is here. Do you see him on the screen?
I do not.
Rafael, go ahead and say something.
Good morning. Do you see me? I'm waving my hand.
Yes, I see you.
Okay.
All right. The court previously found probable cause to exist to believe that you're a runaway. First question, Ms. Guerrero, does detention have her medication in the back, if any?
I need to ask Mom because Ms. Aguirre informed me that the mom was supposed to bring that medication at the initial detention hearing. So let me ask Mom. Señora Flores, ¿trajo el medicamento de su hija?
No, porque la oficial me dijo que no tenía que llevarlo.
She said no, Judge. She did not bring the medication.
¿Por qué no?
She said because the officer told her that she did not need to bring it, is what she said.
Does she remember which officer?
¿De cuál oficial le dijo eso, señora?
Selena Aguirre.
Miss Aguirre's judge is what she's saying.
Okay. Mr. Sierra, let me get your thoughts first, and then also if you want to ask Mom some questions.
Yes, Your Honor. I'd like to say that, of course, as you mentioned earlier, that my client was detained because she was a runaway. She has been in custody for 25 actual days. She is a level 1O, Your Honor. Parent is willing to take her home. Señora Carla?
Sí.
¿Usted está capaz de aceptar su hija el día de hoy si el juez decide a dejarla salir? Un momentito. Are you willing to take your daughter if the judge decides to release your daughter today? Dígame su respuesta, por favor.
Mira, sí, como yo ya había hablado con la oficial y ¿cómo se dice? Una trabajadora de CPS esperando visitar a Jocelyn. Yo le expliqué que nosotros vivimos en un refugio.
My feed breaking up very much. I only understand about every other word.
Señora Carla, es una pregunta simple. ¿Usted tiene la habilidad de aceptar su hija en su casa?
No, porque nosotros vivimos en un refugio.
Padre, no seas así, te lo pido por Dios.
If I may.
Jocelyn, silencio, por favor. Solamente ahora, ¿ok? Solamente.
Judge,
Yes, ma'am.
I was
Yes, Ms.
informed by
Burrow.
Miss Aguirre that mother is living at a shelter. So Jocelyn left the shelter in November. So I was told that once someone leaves the shelter, they cannot go back. So she will not be allowed to go back to the shelter where mom is staying presently.
Well, additionally, I believe she also said she's been trying to work with CPS.
I heard something about CPS, but I did hear her say that I believe that she's staying at a shelter, but I didn't hear what she said about CPS.
Okay, Mr. Sierra, were you able to hear what she was saying about something about working with CPS? I caught that much.
Your Honor, that's the same limitation that I have.
Okay.
Would you like me to ask her again?
Please.
Judge, I do have some information. Sorry. Miss Aguirre told me that mom made a report and a CPS was working with Jocelyn due to her running away consistently. She was taken to a emergency shelter and Jocelyn left with an older gentleman from that shelter. And
Yes.
said, and CPS was aware of that incident. So I don't know if that's what mom is trying to say.
Well, let's let Mr. Sierra ask about that.
Carla, ¿nos puedes decir un poquito más brevemente de tus comunicaciones con CPS, por favor?
CPS ha estado envuelto por tiempo y yo he estado tratando de pedirles a ellos que le den un tratamiento largo. Ella ha estado 3 en un hospital y no ha funcionado para drogas.
Judge, it cut off for me too.
Judge, she said that she's asking CPS for help, that she's asking CPS for long-term treatment, and that she has been hospitalized before, is what I heard.
And does she have a caseworker?
Señora Flores, ¿cómo se llama la trabajadora de CPS que está trabajando con usted?
No sé cómo se llama.
¿Tiene el número de
Un día pues, no.
¿Tiene el número de
Lo
teléfono
perdí.
de la señora?
No.
¿Cómo se comunica usted con ella?
Ella no me llamó una vez cuando y me vuelto.
She said she doesn't have the CPS's name or phone number. I asked her how she communicated with her, and that's what she was telling me. She said that CPS, all I heard is that CPS called her once. Oh, I do. The CPS worker is Sandra. Perdón, señora.
No me volvió a hablar nunca.
She said CPS never called back, but I do have a name of the
Okay.
CPS worker.
Can you share that with Mr. Sierra?
Yes.
Okay. Mr. Sierra, it sounds like right now I don't have a parent or guardian to release her to. So I'm stuck. However, maybe there's something you, Ms. Guerrero, can do to work with CPS. to find an appropriate placement for her, other than our facility.
Okay. I will get with her today, Your Honor.
All right. Jocelyn, I'm sorry. You have been level 1-0 since the 12th. I know that is so hard in the back right now, especially in the girls' spot. But my hands are tied. I'm sorry. I'm very sorry. Okay.
May we be excused, Your Honor?
Yes. Mr. Sierra, is that your last one?
Yes, Your Honor.
Yes, sir, it is. I'm sorry, Jocelyn. I have to order that you be detained today. I'm sorry.
Thank you, Judge.
Mr. Sierra, Ms. Guerrero, can we see something about making sure that mom is able to bring her meds?
Yes, Judge.
Okay.
And Mr. Sierra, I just emailed you the CPS contact information.
Thank you very much. I really appreciate it.
I will call mom about the medication. Thank you.
Okay. All right. Are you Mr. Sylvie Park?
Yes, sir.
I think we've met before. My name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Boyd Mooney, is here. I'll let him unmute himself. Okay. Courts previously found that probable cause exists to believe that you engaged in delinquent. I also happen to know that you're on probation with this court because I believe that I'm the one who placed you on probation back in January of this year. And now you picked up a new offense, a felony level offense of possession of controlled substance listed in penalty group 1, an amount greater than 4 grams at less than 200 grams. All right. And Mr. Thomas, is Mr.
Yes,
Thomas here? Mr. Thomas, correct me if I'm wrong, but when he was brought into detention this last time, he tested positive.
That is correct, Your Honor. He tested positive for marijuana, amphetamines, and methamphetamines, and that was through a hair follicle test ordered by judge.
However, the good part is, what is his level in the back?
He is currently a level 1 as of December 11th.
And has been 17 days. Wow. All right, Mr. Sylvie Park, you have been level 1-0 for 17 days. However, I have to weigh that against your own probation. And your own probation, I'm the one who put you on probation back in January. You picked up a new felony offense. So I'm not there yet. I don't feel comfortable that if I were to release you to the community, you would not be a danger to yourself based on positive drug tests, or to others based on the fact that you were allegedly found with more than 4 grams of a penalty group 1 substance. So on that basis, I'm going to order that you be detained. Thank you, sir.
Thank you, Your Honor. Can we be dismissed?
Yes, sir. Thank you, Mr. Thomas. Thank you, Mr. Mooney.
Thank you, Judge.
All right, Gabriel Solis.
Judge Porter.
Yes, sir.
Before
thank you. Thank you. Thank you. Mr.
But even before we do that, Judge, can we revisit Stallings real quick? I've been talking with Mr. Reed and Mr. Miller.
Yes.
Judge, and please correct me if I'm wrong, Zane or Kevin. I don't think they're going to allege.
Juvenile, take that child off the screen, please. Thank you. All right, Mr. Adler, sorry about that.
It's okay, Judge. Thank you for doing that. I know he's underage. So real quick, Judge, that was going to be a parental placement. So it wasn't going to be a technical violation. So I think we all agree that the mom is going to place and my client agrees to go. So they're not going to technically file anything. We just all agree that the mom is going to place him at TYRC with his approval.
Okay. Mr. Reed, I'm going to go ahead and let you respond just for formality's sake.
Your Honor, if they want to voluntarily do that, we just ask that the court now make it a condition of his probation for successful completion. And I believe that's something that his probation can be modified in that manner without a hearing by the court.
No. We are going from general probation to court-ordered inpatient treatment. That is an increased level of confinement. He has certain due process rights, and that would require a formal hearing rather than just agree to it. And I cannot modify his court to increase his level, modify his probation to increase his level of confinement without a hearing, Mr. Reed. So I cannot order, or I cannot modify his probation sua sponte to order him to complete inpatient treatment without a formal hearing. So, Mr. Reed, that request will be denied. The respondent has certain due process rights, and the court will not run roughshod over those due process rights. Mr. Adler?
Judge, I just want to make sure that he still, but I think the mom could still do a parental placement even under the general terms of probation that we're under, if you're okay with that.
That's correct. That's a different situation. All right. And Mr. Miller, we have he's ready to go today. He's completed his quarantine.
Yes, Your Honor. He's done. And we can also leave the VOCO and let the DA's office use that as, if he doesn't successfully complete, then they can file the VOCO.
Correct. Okay, I'm going to go ahead and authorize his release on the electronic monitor to mom, with the understanding that the reason for that transfer is because mom has arranged for a voluntary inpatient placement at TRC.
Thank you, Judge.
Thank you,
All
Judge.
right. Thank you, Mr. Adler. The law says when a child is under the age of 14, there is a presumption that the child's interest in privacy outweighs the right to the public to participate in the hearing pursuant to the open court's provision of the Texas Constitution. No evidence to the contrary has been brought forth to this court, and so accordingly, the court will close off these proceedings to the public, the remainder of them anyway. And if I can ask Judge Kim to stop the live stream.